Good evening, this is John Milburn for Laws 11062. This is Contract B. We're into week 4 of Term 3, 2019. We have a small group online tonight, but thank you very much for joining us. I do appreciate it. Tonight we'll start with our discussion on estoppel. And to get the fingers warmed up, hi Gareth, nice to see another person has joined us. To get started on the law of estoppel, I'm going to ask for a quick quiz. And that is, if you could please identify me, just using shorthand, what you believe to be the two most important cases that relate to the law of estoppel. So just the short title will be fine. And we'll look for some votes. So Tanya's joined us, Faraz has joined us. Very good. We're looking for the two most important cases on the laws to do with estoppel. Please add your votes as we go. We're getting some votes now. So I'll wait for a few to come in. Thank you, Natalie, you're first in. And you may disagree with my choices because clearly you know that soon I'll be saying these are the two that I'd like you to mention. Andrew, why am I saying Albert? Andrew has come in with one, as has Samara. All right, Tanya's one as well. Okay, so any other people contributing? Going? All right, gone. The two that I think are the most important are High Trees House and Waltons and Marv. Now, if you hear those cases, pretend you're like a meerkat poking your head up to get a listen and find out what's going on. So there are certain cases, certain pieces of legislation that really do make a difference. And the important thing about these cases is that the sort of things that you want to cite pretty much in any question that relates to the topic in hand. So for estoppel, I think you'd really want to include High Trees House and Waltons and Mars. The other votes came in for Hughes and Metropolitan, which is fine also. There are a few other cases that are very important, and I'll emphasise those to a degree, but really concentrate hard when you hear those key cases being mentioned. The odd thing about estoppel is this, that we're really talking about things that don't necessarily relate to contract law, which is very odd given this is Contract B. We've talked about misrepresentation, we've talked about mistake. For those things to apply, there must be a contract. But where a party misleads another in such a way as to cause the other misled party to suffer harm, that may be through estoppel, and there may not be a contract. It may be, for example, that one party says, we don't need a contract, where in fact the parties do need a contract. So there may be some estoppel arguments that apply there. Quick quiz, is estoppel primarily equitable or common law? Or is it to some degree both? The votes are coming in. Is it primarily estoppel, equitable, or is it primarily common law? Or could you argue that it's both? Okay. I like Garrett's answer. Both, but primarily equitable. Natalie says combination. Can anyone tell me the name of the case which indicates that the law suggests that where possible, we look at estoppel as a uniform doctrine operating consistently in both law and equity? So the answer is yes, it's primarily equitable, but it's also common law based. But we try to think about them in a combined, uniform way. Keep this case in mind because it's a useful authority to suggest that we really can look at it either way. So the case I have in mind is the Commonwealth against Verwayen. That's Verwayen. It's 1990, 170, CLR 394. Commonwealth and Verwayen, it's often called the Voyager case And in that case, the High Court did cite Walton Stores and Marr. So estoppel, of course, means something that stops or bars or hinders someone from doing something. Essentially, it means that one can't go back on something that was said or done to their advantage if essentially to do so would be unconscionable. We tend to think of estoppel by conduct, which is closely aligned to unconscionability, which is where it would be unconscionable to depart from denying the existence of an assumption adopted by the other party, where it caused the other party to act or fail to act to their detriment. So that's the Voyager case. So that's estoppel by conduct. Now, promissory estoppel relates to something that was said. So it's a form of estoppel where a representation is made and the law says, we're going to prevent you from resigning from that representation. It's promissory, as in making a promise, a commitment, and you're stopped from going back on that. Often when we talk about estoppel, we're talking about a representation, and quite often that representation is pre-contract. So representation is a word that also crops up quite regularly. Now, you won't hear this too often, but it's fundamentally important. The term estoppel by record. Essentially, it means if the courts have decided a matter, then it can't be re-litigated. And so that's estoppel by record. So when we're talking about estoppel then, we're really talking about something that was said or done by one party, or something that was said and recorded and decided by a court primarily. So estoppel by record really relates to that aspect of a court decision. And it may be that the entire matter has been previously litigated, res judicata, or it may be that there's an issue that has been previously litigated. Now, an example of issue estoppel is named after a High Court case in 1981. So this is one example of issue estoppel. It's a very important example. It's a High Court case, 1981. Can anyone hazard a guess as to the name of that case? If you're thinking issue estoppel, then think this case. Anyone got it? I'm making you work hard tonight. When we only had a few people online, I said, I won't make you work hard. But unfortunately, more people have arrived, so I've got to make you work hard. Thank you, Tony, for joining us, by the way. Thank you, Jasmine, for joining us. All right. The 1981 case that I'm referring to is the Port of Melbourne Authority against Anshun, A-N-S-H-U-N. Pity Whale today, the citation is 1981, 147, Commonwealth Law Reports 589. All right. Just as an aside for your second assessment, when you're citing cases, whilst we regularly refer to the case in that manner, 1981, 147, CLR 589, technically the right way to do it is to say 1981, reported in volume 147 of the Commonwealth Law Reports 589. That's just an aside, but don't worry. I'm happy if you give the abbreviated form. Okay, so Anshun estoppel. It's very important in evidence law. I do take evidence law from time to time. If you're studying that, you will certainly come across it. Essentially what happened in Port of Melbourne and Anshun, which led to this Anshun estoppel, which is issue estoppel, is both parties had been found liable as defendants in an action by a dockyard worker who was injured because of the negligent operation of a crane operator. And the liability was apportioned at 10% and 90%. What happened then is the Port of Melbourne Authority, which was held to be 90% liable to this injured worker, actually then sought to enforce a clause in a hire contract against Ansham, which was 10%, and it tried to make Ansham fully liable, even though the court had earlier determined that the Port of Melbourne Authority was 90% liable to this injured worker. So on its face, it was a different case. Now it's not the worker against Port of Melbourne Authority and Ansham. Now it's Port of Melbourne Authority against Ansham. You see the slight difference there? But the High Court said, no, we're not going to relitigate this. If you thought it was important, you had every opportunity to raise that through the pleadings when defending the action that was brought by the dock worker. So one of the strategies that you ought to have adopted, one of the issues, if you like, that should have been dealt with, and as far as we're concerned was dealt with in the original case, is the liability as between the two of you. So don't bring that action now. That issue has been determined, it's finished. You are now stopped. But from bringing that action, we now call that Ansham Estoppel, based on the 1981 case. Moving on, I mentioned that estoppel is both equitable and common law, and common law estoppel essentially relates to the rule of evidence, presenting a party from leading their opponent to understand that one set of facts existed, and then instead presenting evidence of an alternate state of facts. And there's an example in the notes there. If a party induced a relying party to believe that he'd signed a contract, then the effect of common law estoppel is to prevent that party from denying the representation when in court. So we often hear this term estopped. You are estopped from making this suggestion, from relying on this argument because of some reason. And equitable or promissory estoppel is really what we'll be talking about primarily in this case. In this course. So when we're talking about promissory estoppel, it's really equitable in nature as opposed to common law. And can anyone tell me what they believe would be the key case, at least in Australia, that deals with the general principle of equitable or promissory estoppel? What's the key case in Australia? I'll give you a hint. It was a High Court decision in 1988. Just the short answer, the short version. Tanya's got it, Gareth's got it. You've all got it. It's Waltons and Marr. So thank you very much. Or Walton Stores and Marr. Thank you, Zena. So in that case, the equitable estoppel may apply in the absence of any pre-existing relationship. So the key in Waltons and Marr is that Waltons induced Marr to believe an offer would not be revoked. That was the key. So there wasn't actually this contract, but there was a set of facts that caused Marr to expend a lot of money, to undertake a lot of work, and it was all on the basis of what Walton Stores had suggested would happen. And when it didn't happen, the High Court said to Walton Stores, you are estopped from denying the existence of what it is that you said that had the effect of inducing the other party to act in a certain way. So we call that equitable or promissory estoppel. All good so far? How many elements are there for determining the existence or otherwise of equitable or promissory estoppel? This is from Walton Stores and Marr. We're getting some votes. 5 seems to be the popular number. 5. Everyone's saying 5. I'll bet that's what's in the study guide, is it? I actually say the 6. Tony says 6 or 66. Was that a typo, Tony? Did you hit the button twice? 6. All right. Okay. Thank you. Glad you didn't say 666, Tony. It's not that bad. All right. So there's got to be a representation. That's pretty obvious. There can't be an estoppel, which is promissory in nature, unless there's a representation. Usually it's words, doesn't have to be. It might be some other form of representation, but there's got to be a representation. That's number one. Number two, it must have the effect of inducing the other party to rely upon the representation. That's number two. Number three, the person to whom that representation was made must then rely upon it. So there must be it must seek to induce the party, and then the party, number three, must rely upon that representation. Number four, the party making the representation must know that the other side is relying upon it. Number five, the party that received the representation must have some detriment caused as a result of relying upon it. And finally, number six is the party that made the representation must have failed to act to avoid that detriment that they could see was happening. So if you have a question in relation to all of this and you're trying to argue the evidence, if it's a court case, you're identifying these key words and you're looking for evidence as to, in fact, whether the intention was to induce the other party, was there reliance, did people know, all of those things. But the general effect is that once you've established the existence of the promissory estoppel, the remedy is essentially to stop that party that made the representation from resiling from that representation. In other words, the effect is that the representation is, for all intents and purposes, true. And as a result of this representation, the party making the representation, think Walton Stores, is required to compensate the party that received the representation, think Ma, because of in relation to any loss suffered because of relying upon that representation. Now, there's been a historical development to this. So if you want to know how we got to this point, the progression, I think, in terms of cases is number one, Hughes, number two, Birmingham, and number three, High Trees House. High Trees House was 1947. Walton Stores and Ma, from memory, was 83. So I think this is in your notes. You can read about the progression. Hughes and Metropolitan Railway, 1877, 99-year lease. Tenants were required to complete repairs and maintenance within 6 months of being informed by the owners of that work that needed to be done. Had to be done by April. Then there were some discussions between the landlord and the tenant about maybe buying out. The result of that was that the tenant couldn't meet the deadline in April because of the negotiations that were happening. They didn't take the steps that were necessary. When we got to April, the landlord said, well, you haven't done the work, so we're evicting you. And the House of Lords said, no, the 6-month period during which the tenant ought to have done the work should be suspended because it would now be inequitable for the owner to rely upon the original deadline when these discussions were taking place genuinely that would have led to an entirely different result to the obligation to undertake the work. So what it showed, what that case showed, what Hughes showed is that in some circumstances, equity would be prepared to enforce representations even if there was no consideration. And that was really the key point of Hughes. There's no consideration for this, but the court said, no, even though there's no consideration here, we will allow the representee the benefit of estoppel. Now that developed on in Birmingham, 1888, where Bolton had a contract with a land company to develop some houses, and Bolton directed the land company to suspend building the houses. And the court found that by making that direction, Bolton had effectively given an undertaking that he would suspend the lapse of time under the contract. In other words, estoppel it's almost in some ways, you can't have your cake and eat it too. You can't create this situation and then say, oh yes, but this is the original deal. Now, High Trees House went further, and this was as a result of the judgment primarily of Justice Denning, who later became Lord Denning. So High Trees House, it's a wartime case. The Property Trust, Central London Property Trust, rented the block of flats to High Trees in 1937. The war broke out and High Trees negotiated with the Property Trust so that the Property Trust agreed to accept half rent. There's a war on after all. That agreement was reduced to writing. It was not an amendment to the original contract, but it was in writing. And at the end of the war, the Trust then sought collection of the rent at the original rate and wanted to collect the arrears during that time when it was only paying half rent. So Justice Denning's judgment and the decision generally in High Trees House took the situation further, didn't it? Because it said that the Property Trust had made a promise in circumstances where it made it clear that the intended promise was to be legally binding. High Trees had relied on the promise, and the Property Trust ought to have known that High Trees would have done that. So where there's a representation that affects legal rights, and it's intended that both be acting upon that, promissory estoppel prevents the party that made the representation from acting inconsistently with that representation. And it operates as a defence in some ways as well. So then, of course, we get to the point of Walthamstow and Marr, 1988. So I said 83 before, it's 88. The High Court set out the rules for equitable estoppel. So in that case, we probably know the facts. Walton's was to purchase some land for its business. The seller agreed to knock down an existing building and build another building in its place to Walton's specification. Timing was important. When time ran short, they sought an assurance from Walton's and they were looking for confirmation that the contract would be signed. Walton said yes, approval would be forthcoming. So the sellers knocked down the building without the formal agreement. Then Walton's underwent a restructure and basically said, we're delaying the completion of the sale, and then eventually said we're not proceeding at all with this purchase. So the seller had invested a great deal of money in attempting to demolish and commencing rebuilding, as Walton's had initially requested. Now, strictly, of course, there was no contract. So therefore, and this is the odd part, we're talking about this in contract law, there was no contract, so the seller had no strict recourse against Walton's, but the majority of judges started by considering unconscionability and talking about promises made in the form of non-contractual representations, and basically came up with this principle, which is reflected in the 6 elements that we talked about earlier. If the party that makes the representation in going against their word was such that it was contrary to the elements of good conscience, to the point where the court could simply not permit it, then equity will find a way, equity will intervene. So the effect of Walthamstow and Marr is this, that promissory estoppel can occur in pre-contract negotiations There's no need for the pre-existing legal relationship. Promissory estoppel could be used to support a case of action in contract. And Walton Stores and Marr is landmark case because it departed from the idea that consideration is a necessary element. And there was no consideration for the alteration in this case. So they're the key cases in that kind of progression. So I think from the perspective of answering the question, I would probably start with Walton Stores and Marr, look at the elements and see if it fits. And then when you're answering the question, perhaps you can introduce commentary that might be relevant from some of these other cases that we've referred to tonight. And if you had a second case to name, I think it would be High Trees House. So we'll just go through those elements again. Firstly, there must be a representation. In most estoppel cases, that's usually easy to identify. And silence, you've got to be very careful, is not acceptance. Remember, that was Fenthouse and Bindley. The second element is that the representor must induce reliance. In other words, the party that makes the statement, that says something, must do so as to leave the other party in a belief that they can rely upon that representation. That's the inducement part. One of the tricks when examiners ask questions about this is to float the idea that this looks to be an estoppel case, but it may be that the facts fall short of establishing that there was an actual inducement to rely upon the representation. Now, the third element is that the party receiving the representation must actually rely upon it. If they don't rely upon it, then there is no estoppel case. So the change of behaviour, if you like, must be directly attributed to, and as a consequence of, the statement that was given to them. So in Walton Stores and Marr changed behaviour directly as a result of that which was said by Walton Stores. And the representor must know that the other party is relying upon the representation. In other words, they must know that they're taking them on their word, that the promise that was made, the statement that was made, was, if you like, important, and they knew that the other party would rely upon it. Then, of course, there must be some detriment, and finally, the party that made the statement can't just sit back and allow this to occur. It must be established that they did nothing to make the situation right. So do you think that we'd be able to identify the elements of promissory estoppel? Bearing in mind that promissory estoppel is not all estoppel, but it's the main one that we're talking about in this unit. And you'd still need to distinguish promissory estoppel from common law estoppel, estoppel by record, issue estoppel, which is and shun estoppel, things of that nature. Are we all good? So what's the remedy? Is there a particular remedy? If you can establish estoppel, what are you going to ask the court for? Because it's one thing to say, hey, this isn't fair, but the next question is, well, the court will say, well, fine, but what do you want me to do about it? So what's the remedy? Okay, we're getting a few votes. Thank you, Natalie. Thank you, Tanya. First in, injunction. Any other remedies? Are we restricted to one remedy? Can we ask for more than one? Bearing in mind that promissory estoppel is essentially equitable, we'd be thinking about equitable remedies, wouldn't we? Is it possible to claim equitable damages? Is there such an animal as equitable damages? Compensation, says Tanya. And Natalie agrees. Yes, there is. You can ask for equitable compensation as well. So the remedy may well be an injunction to stop that party from relying upon the statements that were made. Compensation would also be appropriate and quite common. Right, so what are the key points then when we talk about estoppel? The first is that it's different from misrepresentation, and it's different from the statutory prohibition on misleading or deceptive conduct. That implies then that if you're arguing estoppel, you might also, in certain circumstances, argue misrepresentation, and/or you might argue misleading or deceptive conduct under the Australian consumer law. You're not limited to one argument. So it may be that if you were preparing pleadings for this, you might plead in the alternative. So it's possible that one action creates multiple causes of action if you're seeking a remedy. But estoppel is different from misrepresentation, and it's different from misleading and deceptive conduct. Sorry, the next key point is this. Estoppel really relates to inconsistent conduct. That's kind of a key to it, isn't it? It arises where something has been said or done, the other party's done something which is against their interest, and now the first party can't depart from the assumption that was set up by them in the mind of the other party. So it's really talking about inconsistent conduct. On the one hand, you said this, you did this, and now you're saying something else. It's quite inconsistent. So look out for that as a hallmark of estoppel. Next key point is this. Promissory estoppel operates where the party making the representation induces the party that's relying upon it to believe that certain contractual rights, if there is a contract, will not necessarily be enforced. Another key aspect is that if the party that receives the information changes their position, as we say, in reliance on that representation, then the party making the representation will not be allowed to enforce their rights. That is, if the party that received the representation believed it, relied upon it, and acted to their detriment. So another hallmark is, can we say there's been a change in position? Because if the party that received the information really may have relied upon it, may have believed it, may have acted upon it, but if they really didn't change their position, then there really is no basis for estoppel. The next key point is, and this is Walton Stores and Marr and High Trees House before it, valuable consideration is not an element of promissory estoppel. So that's a key hallmark. The next is the court will endeavour to place the innocent party in the position they would have been had the party making the promise not resiled from that promise. So in terms of remedies, and we've talked about injunctions and compensation, ultimately the main aim is to initially stop the party from continuing to act contrary to their position, but secondly, put the innocent party back in a position where they would have been except for this occurrence. And the final key point is that in Australia, the doctrine is largely set out in Walton Stores and Marr. So that's the key case when it comes to dealing with promissory estoppel. So an innocent party will have a remedy, even though there may not be a defined contract or even necessarily pre-contract discussions. Walton Stores and Marr is the case that you always come back to determine the elements and compare what you've got in front of you in a case compared with what happened in Walton Stores and Marr. So that's the key case for promissory estoppel. Now, with that, I propose to now talk for a while about something completely different. Before I do, are there any questions, comments? I know I've been doing a lot of talking. Thank you very much. All good? Okay. My question is, in the little break from contract B for a moment, does anyone have any involvement with community legal centres? And if so, have they found it a rewarding experience? While you're thinking about that, I'm just going to share the screen with a website that you might find useful. Hopefully now you can see the website for Community Legal Centres Queensland. I'd urge you to look at this, get an idea of what community legal centres are doing. And there's one there from the Taylor Street Community Legal Service, which I helped to co-establish many years ago. That's in Hervey Bay. So community legal centres are all around Queensland. It's a great service, and as law students, it's a valuable resource. And if you have the opportunity to engage with the community legal centres, that would be an excellent opportunity for you to broaden your horizon, get to know some practitioners. And certainly, whilst I don't volunteer any longer, it was always my practice that when I would volunteer to provide free legal service, I'd ask the clients if they would allow me to have law students join in, and the law students would then have some opportunity to engage in legal interviews. So please keep that in mind because it's a valuable resource. Now, while I've got that on the screen, just remember a couple of things from Introduction to Law. When you're answering questions, it's probably a good idea to use some legal logic and legal writing skills. So, of course, legal logic might be the IRAC method or MIRAC, CIRAC method. But don't forget things like deductive reasoning, inductive reasoning, reasoning by analogy. These are all potentially important, so brush up on that. So, for example, deductive reasoning is where you, number one, state a proposition, number two, make a statement of fact, and then number three, draw a logical legal conclusion from that. And it's kind of becomes a habit, becomes a way of writing. So they would be the useful ones for you to consider. Another is when you're answering a legal question, it's useful often to know and identify the first word, because examiners in an essay style question are looking potentially for different things. So if the examiner asks you to interpret something, that means determine the material facts, typically. If the examiner asks you to analyse, that means in part find the hidden features. If you're asked to evaluate, that means assess something. If you're asked to infer, that means your ability to draw conclusions. So look out for those aspects, because that can be a key as to what it is that you need to do in answering a legal question. So that's our little divergence for this evening. And now we'll get back into it. Duress, undue influence, unconscionable conduct, which is really the topic for week 4. Chapters 15 through 17 in both your text and your chapters. I'm going to ask another question, keep you on your toes. If you had to name one key case where, like meerkats, your head comes up out of the ground and says, whoa, I've got to pay attention now, I've heard the name of that case. What is, in your mind at least, the key case that relates to duress, undue influence, unconscionable conduct? There might be a few answers. This is just my idea. We're getting a few votes coming in. Thank you, Tanya. Thank you, Gareth. Thank you, Andrew. And you've all identified exactly the case that I had in mind, which is shortened to Amadio. So the Commonwealth Bank against Amadio, usually Amadio, key case. So if you hear that, please pay particular attention. And if you're answering a question on this topic, you'd almost invariably want to refer to that case and work your answer around it. A couple of things about duress. Three interesting little facts on duress. The first is that duress is a term that we use in contract law. What other subject do we hear the word duress as a topic? That's a pretty easy question. Criminal law. What do we call criminal law? What's the shorthand version? Crim. Everyone just says crim. So in criminal law, absolutely. What's the key difference between duress in criminal law and duress in contract law? I'll give you a hint. They basically mean the same thing, but when it comes to the application of duress in criminal law as opposed to duress in contract law, which is civil, and there's a big hint, what's a key difference when it comes to establishing or proving? What's the level to which you need to prove something in criminal law as opposed to civil law? Very good, Tanya. Yes, you just beat Tony beyond reasonable doubt. So when we're talking about duress in a criminal law context, we're really talking about much the same principle. It's just that it's got to be proved beyond reasonable doubt in criminal law, civil law, contract law. We're talking about something which is on the balance of probabilities. Second thing is duress. Vote. Is it a common law remedy or is it an equitable remedy? Or is it both? What are your votes? Gareth has voted. Any others? You're right, Gareth. Tanya's voted. I'm going to go with Gareth's answer on that one. Common law. Common law. Duress it's a common law document. Now, undue influence and unconscionable conduct, they're equitable. So there's a basic difference there. And unlike the first matter that we discussed tonight, there's really not so much of a practical fusion. They've tended to remain separate. Now, in a way, it doesn't matter, except for perhaps two reasons. The first is that some courts will allow equitable arguments, others won't. So, for example, we don't really see equitable arguments raised in the magistrate's court. The second key point, probably the more important, is that remedies are different, aren't they? For common law versus equitable remedies. So in that sense, it's important to understand and keep that in mind. So when you're preparing your notes, ready to answer these questions, you need to be able to refer to your toolkit, your quick guide, your ready reckoner, whatever you want to call it, that gives you some idea of these aspects. So duress, of course, means that one party is forcing or bullying another into doing something. So it's overbearing behaviour is what we often see. The case there, Crescendo Management against Westpac Banking Corporation. It's probably not in your notes, but Crescendo Management, Westpac Banking Corporation, 1988, 19 NSWLR 40. So in that case, the court described duress as relating to coercion, as relating to overbearing behaviour, and described it as illegitimate pressure beyond what the law is prepared to countenance as legitimate. Now that's interesting, isn't it? Oh, it is in the notes, says Tanya, so thank you. So duress can be physical or it can be a threat. It might be that it's where the concept goes, the pressure goes too far. Like if people are in a commercial situation, even if you're buying a house or if you're buying a car, there's pressure, isn't there? And we've got to be a bit careful here. We've got to be a bit robust because, 6 months after someone buys a car, it might be a perfectly good car, but they might, their friends might be saying, why did you buy that car? Blah, blah, blah. They can't say, well, I was pressured into it. I really felt pressure while I was at the car dealership. Well, if you put yourself in that environment, you expect some degree of pressure, don't you? But the court will say there's a difference between the pressure that's legitimate and the pressure that just goes too far and it's illegitimate. And it's really hard to identify that. But that's the nature of duress, isn't it, at common law? Now, undue influence is where one party seeks to take advantage of another party that's willing, but their judgment is impaired. And that involves a different mindset and a different way of thinking. So when we talk about unconscionable conduct, which is the third one, we tend to think about special disability or special disadvantage. So they're some of the cases. So the key case, Amadio, that's 1983 High Court decision. So 1983, 151 CLR 447. So it's the equitable principles relating to relief against unconscionable dealing and principles relating to undue influence. They're closely related. This was part of the decision, but the two doctrines are distinct. Undue influence, like common law duress, looks at the quality of the consent. Unconscionable dealing looks to the conduct of the stronger party in attempting to enforce or retain benefits against a party with a special disability. So you can see from that quote, and this was Justice Dean at 474-475 of the authorised report, who made those comments. So we can say that duress is common law and it looks at the quality of consent. Then we have undue influence, which is equitable, that looks at the quality of consent. And then we have unconscionable dealing or unconscionable conduct, which is equitable, that deals with a comparison of the stronger party attempting to force or retain benefit against a party with a special disability. So that's kind of what you'll need to do, is have a clear note as to what it is that what you believe to be the appropriate way of describing these things. And if you can mention Amadio and give a quote that identifies it, so much the better. So unconscionable dealing, unconscionable conduct is where people under a special disability are in a position where they can argue that a contract should be declared ineffective. Just because you're a minor, or even if you're mentally ill or intoxicated, you can still make enforceable contracts. So don't think that people under a special disability can never be bound by an agreement, but it puts you in a certain category where it can be argued. So when we're talking about unconscionable, we're really talking about a degree of exploitation, aren't we? And I guess the questions that you need to ask yourself are, number one, does one of the parties have a special disability? And number two, is the nature of that special disability such as to result in inequality of bargaining power between the two? Then the party without the special disability needs to show that the contract should be enforced. So in Amadio, the situation was that Amadio established to the court satisfaction, we have a special disability, number one. Number two, the nature of our special disability is such that there is an inequality in bargaining power. And once you get to that stage, you can almost see the court changing its attention from one side of the bar table to the other, saying, all right, bank, we've now got, you've been dealing with people with special disability, and they've established there's an inequality of bargaining power. You now have to show why the contract should be enforced. So the onus shifts, doesn't it? And that's a key element of the Amadio decision. Any questions so far? All good? You're doing well. So a key part is to establish this special disability. And the disability must affect their capacity to make rational decisions. So a key case is Plumlee against Ryan. It's 1956-99 CLR 362. And the court said that there's a pretty wide definition here. And a person with a special disability might include poverty or need of any kind, sickness, age, sex, infirmity of body, drunkenness, illiteracy, lack of education, etc. Or it may be that there's a common characteristic of someone being at a serious disadvantage as against the other one. So in Plumlee and Ryan, there was a contract for the sale of some grazing property, and there was an action for specific performance by the buyer. The vendor had agreed, but was affected apparently by a long bout of rum drinking, and the claim was to set aside the contract as a response to the action for specific performance on the basis that it was an unconscionable bargain. That in that instance, in Plumlee and Ryan, as a result of being adversely affected by the drinking of the rum, the drunkenness, that there was a special disability. And the court accepted that. They said that the category of special disadvantage or disability is not closed. And the quote there, I think it's in the notes, Fulliger at 450 said, the circumstances adversely affecting a party that might induce a court of equity to refuse its aid or set aside a transaction are of great variety and can hardly be satisfactorily classified. And so there was that list that I mentioned earlier: poverty, need, sickness, age, sex, infirmity, drunkenness, illiteracy, lack of education, lack of assistance or explanation. And that all led to the Amadio decision. In some ways, you don't need to know the facts of these cases. In some ways, you can get by having some idea of the principles that were established and being prepared to add in some quotations. But Amadio, you need to know the facts. And part of the reason for that is that when you're answering a question, in your mind, you might be going through the elements that were established in this case, but also cross-referencing to the facts so that it gives you a good point of reference. It gives you a good comparison. So let's briefly look at the facts as they arose in Amadio. Now, Mr. and Mrs. Amadio had a son, Vincenzo, who persuaded them to sign over their home as security for a business loan for himself. And he needed the loan and the security to satisfy the bank. He needed that money badly. And he misrepresented to his parents that the security would be for $50,000 for 6 months. But in fact, the liability to the parents was much more than that. Now, Mr. and Mrs. Amadio didn't attend the bank's office to complete the transaction. The bank manager, Mr. Virgo, visited their home. The Amadios had spoken little English and they knew less of writing in English. They required an explanation of the documents, but the bank manager failed to do so. He actually heard Vincenzo say something to his parents about a 6-month limit, but there was no correction of that. So Mr. and Mrs. Amadio, they didn't know that their son was unable to meet the loan repayments, but in that situation, their house would be at stake. The bank didn't take steps to ensure the Amadios genuinely consented with a proper understanding of the agreement. And of course, the company that Vincenzo was operating defaulted. It had borrowed an extra $91,000 on the overdraft just a few days later, and then it went into liquidation. So the bank, of course, had all the documents lined up ready to go, sought payment under the security from the Amadios, and sought to sell the Amadios' house. Now, the Amadios weren't under a physical disability, were they? They weren't under a mental disability. They weren't intoxicated, but they were still, as far as the High Court were concerned, under a special inability to properly attend to their own interests. And that's a key aspect of it. So Amadio, really important. And it's fair to say that the modern elements of unconscionable dealing were set out in the Amadio decision. Of course, when you're talking Amadio in practical sense, you'd also want to consider the Australian consumer law and consider how that might be used as a means of taking action. And can anyone tell me typically what type of order would you seek? And bearing in mind this is an equitable remedy, what type of order do you think you'd seek if you're alleging a special disadvantage on behalf of a client in the context of unconscionable conduct or unconscionable dealing? What's the primary remedy, do you think? This is the last thing we're going to do for tonight. And we'll pick up next fortnight. Rescission. We're getting some votes for rescission. Thank you, Tanya. Thank you, Natalie. Thank you, Gareth. Yes. And if you rescind, what ultimately do you seek from the court? I think, have a look at this for next time, but I think you'd ask the court to set aside the agreement, to make it of no effect, essentially, is what you're really asking for. So the Amadios essentially were saying, we don't want any of this. We shouldn't have been placed in this situation because of our special disadvantage. And Zena says, go back to the original position, as does Gareth. Yes. So one of the important takeaways, well, there's a few important takeaways from tonight. The first is that as you're reading the material, identify what you believe is the important case or cases, the ones that you'll really hang your hat on in answering a question, and know something about the facts of those cases and know the important principles. That's one thing. Second is identify, wherever you can, the difference between the common law and the equitable remedies. And of course, later in the unit, we'll be talking about the statutory remedies as well. And then finally, try to have firmly in mind what it is that you'd ask the court. If you can establish that something is wrong, the next question is, well, what do you want me to do about it? So you need to know that further thing. What is the remedy? What are you going to do about it? And what's the basis for it? Okay, so all good? Any questions before we wrap up? You've been very patient, very good, thank you. Now, we're not meeting next week, are we? Can anyone remind me? I think next week is a break week. So we'll be seeing you in 2 weeks from tonight. Okay. And just a reminder of two things before I wrap up. Number one, tomorrow is census. So whilst I don't want to see anyone leave, if you do wish to pull out of the unit, you've got to do that by tomorrow without penalty. And the second is, don't forget your assessment. And remember, of course, it's always difficult to get an extension out of me. So if you are asking for an extension based on something that you knew was going to be the case in week one, you probably won't get it. So don't be disappointed by that. Okay, very good. Okay, we'll see you in 2 weeks. Thank you very much. Bye then.